Dear friends, in my previous videos, I told you, and even there was a problem for the CPC student, final year students. So at that time I told you, the priest, he has suddenly fell ill and he is not able to recoup. Therefore, he wanted his son to get the hereditary archicaship. Will the court allow or not? I told you the so-called ennobles tribunal, all these things. So that is relating to the compassionate appointment on compassionate grounds. So please remember, it is only a solace, it is not a right. So Supreme Court held that compassionate appointment is not a matter of right. It is provided to enable the family to tide over an immediate crisis. So this was held by two judges bench, Honorable Justice A.S. Bopanna and D.Y. Chandrachud. While hearing an appeal in the judgment of against the judgment of Madras High Court in the case of Union of India versus Amrita Sinha. Union of India versus Mrs. Amrita Sinha in civil appeal. It's a civil appeal number 7640 and 7641 by 2021 on 11th December 2021. So they clearly observed that the compassionate appointment is not a matter of right. If you know the brief facts, then it will be better for you to appreciate. Amrita Sinha's husband, he was working as in the Air Force, Indian Air Force, as Sergeant Cadre, and he died on 6/1/2008 due to cancer. While working in the Indian Air Force, he died due to cancer in the year 2008, of course. At the time of death, the husband, that is Sinha, he left behind his wife and two children, right? So actually, Amrita Sinha, she filed a petition for compassionate appointment. Of course, they rejected the same in the year 2011. Once again, 2014, she applied, but in 2015 also, it was denied that she secured the merit points, which will not enable her to get the compassionate appointment. That's the main problem. Actually, Union of India gave memo number 13, I think, in 1998. I think they are given memo number 38, whatever it is. In 1998, they gave a memo regarding the scheme of compassionate appointment under central government. But she was not qualified. She was not considered. So this provision, this scheme is not applicable to her. And incidentally, actually, she was allowed or she was granted a pension of rupees 8,265 per month. But due to the merit points, her pension has been reduced to, I think, 4,959 from 2018. 10 years she was given 8,000. Now it is reduced to around 5,000 or so, because she was given the benefits up to 23 lakhs or so. So some calculations are there. So therefore, with the calculations, her pension has been paid. So now the Indian Air Force did not give her any compassionate appointment, and moreover, her pension has been reduced. So she filed a petition in the Central Administrative Tribunal, CAT. So then CAT also actually considered her application and directed the Indian Air Force. Yes, the Air Force is saying that the pension policy is not correct. So, and therefore, she may be given some suitable appointment. It was not considered. Ultimately, Union of India went in appeal to the Honorable Supreme Court. Supreme Court said that there is a scheme. The scheme has to be applied for each and every person. If the scheme does not permit her to take the compassionate appointment, then we can't help. It is not a matter of right. She also is she has to abide by the rules and regulations, is it not? So as regards luckily the Supreme Court considered the policy decision regarding the so-called pension, and they stated that it should not be to the disadvantage of the bereaved family. When you started giving 8,000, sir, you must enhance it to 10,000 or so, but you should not give revert it back to 5,000. It's not correct. So anyway, please enhance her pension. At the same time, she cannot claim that the so-called compassionate appointment as a matter of right. Good judgment. Please read it, and definitely you will appreciate the judgment. Thank you very much.